Noelle is one of our top attorneys on the team, estate planning, asset protection, probate, and trust. And so we're going to go now into some highlights here on a few areas. First of all, the bill that came out of Washington, it's a big deal. We actually, as a firm, have been doing a ton of education on, I think the official name is called a Big Beautiful Bill. Whether you think it's beautiful or not, that's the name of it. And it's out there. And excuse me. So our founder has been a lot of education. Noelle's getting out there, and people want to know about this. It doesn't matter if it's a small business owner, families, a bigger business. There's a lot in this bill. Noelle's going to highlight some of them here today, but just know that we're on top of this for you, and it's a topic that should be coming up with clients in a lot of different areas. And so, with that, Noelle, I'm going to
Yeah.
pass it over to you. Let's take it away. And I know, Amanda, you've got questions.
Yeah. Before Noelle jumps in there, I'm going to ask you guys in the chat. I'm going to ask you a question about the big, beautiful bill. Let's see what you guys know. What is the new estate exemption per person starting in 2026?
And to a degree, yeah, it might be unknown in the future, but we know what it is now, at least for this presidency and this term. Um, Congress is always changing estate tax exemptions. It's one of the most discussed issues amongst tax planning, revenue generation for the government, as well as taxing the rich, essentially. And so that does become a political issue. I don't really align with any one particular party, but in today's discussion, really the focus is for practitioners and those of us who touch and concern our clients' lives on the financial perspective and estate planning perspective. What does it mean for an estate tax exemption amount? First of all, what does that mean? What does it mean for it to be changing? And what does that mean for planning in the estate planning arena as we utilize tools like trusts that help us with transfer of wealth? How do we maximize that transfer so it's best suited for our clients, it's best suited for their goals, and reducing any estate tax or the transfer tax upon death? So yes, drum roll, 15 million is the estate tax exemption per person effective January 1st of 2026. So for now until then, if somebody would pass away today or yesterday or any time between now and the end of the year, they would fall under the current law, is my understanding, which is the, past sunset 2025 laws, which when they were enacted would have expired by the end of this year. And so would put us back into historical lows of maybe, which is pretty high, but 6 or 7 million, 5 to 7 million, somewhere around that range per person. And so now that Congress came in and sort of permanently made that change, meaning they've took away this expiration nature of the estate tax exemption and now included a minimum surety that 15 million per person is granted. Very important to consider, though, this is still on the federal level. Okay, so estate tax exists on the federal level. It also exists on the state levels, depending on where you are in the nation. Each state still has their own rules. And so, from an estate planning, financial planning perspective, you do have to consider what the state rules are. They'll never be in conflict per se with the federal government. They're never going to say you can have 18 or 20 million, right? They'll still be in line with the federal government, but they may say on the state level that they'll follow something different, which means there still needs to be local planning for the purposes of what this state estate tax would be. But for at least where we are in California, California follows the federal. So for our clients out in California, we are assuming if they're a married couple, they will have about 30 million with inflation, 30 million to work with for transfer of wealth without taxation. And that could mean they could transfer wealth during their lifetime. We could do advanced planning, gifting, which gifting takes away from the estate tax exemption. So if you have 15 to work with and you gift five, you have 10 left upon your passing. So that's how that works. A lot of you know that already, but it's good to get a refresher reminder. So what does it mean if the 15 million is now in place for a married couple, 30 million with inflation? It means that it opens the door for a lot of opportunity for planning. Trusts that were drafted many years ago with the expectation of the sunset laws to have expired by the end of this year. We're all kind of biting our nails trying to figure out what's going to happen in the estate planning arena and the tax planning arena. Now we have that clarity, at least for this term, with the expectation that it may be very difficult to unwind it for future terms just because of the at least perceived permanency. But with politics, things can change at any point, especially with strong pendulum swings in either direction. So if you have clients, you're working with folks who are interested in revising existing documents, this is really the perfect time for that because prior trusts may have been drafted in a way that is not tax advantageous. There are certain trusts which, for their time, would have been great given the estate tax exemption at that time, requiring assets to be split into a decedent's trust and a survivor's trust upon the first spouse's passing. This is in the context of a married couple. Um, in the context of a single person, then it is what it is, right? We have that 15 million to work with. But a lot of trusts for married couples that were designed to be split at the after the first partner passed away to maximize that tax advantage, those may not be necessary, especially if we're not seeing even projecting a 30 million value of an estate for the married couple. And that's important to come back and see, does it make sense to keep the structure? Does it make sense to revise the structure? Because all the assets that get put into the decedent's trust, which is typically half of what the couple has, they do get locked out of the survivor's estate, which is nice. They won't get counted as part of the survivor's estate, but we also don't get a double step up in tax basis on those assets. And so if we know for a fact that they're all going to go to the same beneficiaries and same loved ones, regardless, it may not make sense to not get that double step up in basis and keep everything on the survivor's trust side. And upon the survivor's passing, everything steps up in tax basis and we have much less of a headache for capital gains analysis to deal with. That's, in the event that the planning is fairly straightforward and we're not trying to change the beneficiaries or have any kind of structure to the trust that limits control. But that's all can be identified within the planning consultation or the attorney advisor relationship to determine like what's going to make sense. But there's trusts where we can make it an optional to do the split, which is really nice because then it's sort of the best of scenarios. We don't have to split the assets upon the first survivor's passing, but we may. And that's nice because it helps us pivot for tax purposes, but gives us the benefit to keep it straightforward, keep it one trust for the survivor, everything steps up in tax basis and we're good. I would say that the biggest implication, at least for families, for business owners, is to think about, is the size of their estate going to be more or less than the estate tax exemption now that we know it's in the more higher permanent range? And if it's projected to be more, then this is the best time to do gifting, the best time to take advantage of what we know is the historical high exemption and use it. Because if a transfer proper present gift is made in real time under current law, it will be honored regardless of what the future law will be. And so if the future law reduces the estate tax exemption and slashes it significantly, we've just saved our clients millions of dollars in estate taxes. And so for planning purposes, this could be huge for family and for transfer of wealth across generations.
Great information. So one thing that comes up usually in this process of setting up trust and questions are around it is the probate process. And I think unless you've gone through probate yourself or a family member, for those of us that haven't, thank goodness, but you don't know what it's like to go through it. So we were talking about, Noelle and I were talking about this. Well, what would be good for everybody to know about going through the probate process, and that would maybe lean some more opportunity for opening the door for those that you're working with that could protect themselves. And as you guys put, not give up control or time and a lot of those things. So, no, I'll let you talk on that.
Yeah, absolutely. Good, great answers. Control, loss of control, a lot of time, your inability to choose who you want to be the executor of the estate. Those are all valid reasons why avoiding probate makes sense. And what you're giving up is the alternative, right? In lieu of probate, we could do planning where you are in control, where time is on your side, and you can choose who is managing your estate and how assets transfer. And I think the biggest benefit of avoiding probate is making sure things are private. I do think that we value our privacy, we value our family's privacy. We don't want people to know necessarily generally public information about who our heirs are, what assets they're going to receive. Solicitation is really high in the probate arena. People just have information to the heirs and their address and what money they're going to receive. And so I think in a large perspective, you do give up that privacy almost instantaneously, regardless of who is the administrator or executor of the estate. And that could be, depending on what attorney you work with and the family dynamic and the laws of the state you're in, it would dictate who the has priority of appointment to be the executor or the administrator, depending on if there was a will or not. Because even if you just have a will, your estate still goes to probate. The only way to really avoid it is to have everything be pay on death arrangement and a trust. To make sure that we can avoid probate. So even folks with a will still find that their estate goes through probate, and so it's important to know the local state laws about, well, if I pass away and my estate goes through probate, who would have priority of appointment? In other words, who would be entitled by default to be the one who raises their hand in court and say, okay, Your Honor, I petition to be the administrator, give me the power and bestow on me, right, what's called letters of administration, which is the ability to go out there and act on behalf of the estate with authority by the court, and then come back and represent to the court what's happened. And that's essentially the role of the executor and the administrator, is to go out, find whatever assets the estate exists, and come back and present to the court an accounting and get approval for how things get divided. If there's a will, then we have some idea of how things get divided. Otherwise, it just follows the default in the probate code, which could be to the surviving spouse or to the kids or next class of heirs of family members who are alive. And it's just pretty cut and dry. It's a rule, it's a formula, it's a class of people depending on lineage or relationship. And so in terms of control, it just isn't there. If you have a will, you have a little bit more control in that process because you can get out of what the default in the probate code is for distribution of assets. But otherwise, it's just going to go to, let's say you have no spouse and no kids, it'll go to your siblings. If you're estranged from them, too bad, right? That's just what the law says. And then I've had cases where folks have been maybe separated, but not completely final divorce, married, soon to be divorced, and that can have an implication. And so, if you pass away during that time, your spouse who you're separated from could actually receive a lot or all of your assets, depending on how the law is in the local state, and whether you've actually received a final judgment of dissolution of marriage or not. So, a lot of things to consider. A lot of things can go wrong, and these are just, I would say, some examples. You've probably heard of all the other examples of just how long it takes and how difficult it is to keep waiting for approval from the court, and everything is essentially frozen until the administrator has power to act over it. And then there's a lot of notice requirements, and it could take a long time. And by long, it really depends on the state you're in, regardless of the value and size of the estate. But in California, it can take up to 3 years or more. We've seen it where it's taken more, and even for a simple estate, due to, yeah, tax issues or um, some disagreement about something the executor did, and so it has to be resolved. And so there's open doors for litigation, and for the heirs to contest something. And sometimes it's totally baseless, but you still have to kind of ride the process because they have access and there's a court case and they can file something, and it just makes things a lot more difficult. Not saying that litigation is not possible in the trust setting, it's just much more easily resolved. The interested parties can resolve their disputes internally and settle the issues privately between them and their attorneys and the trust and the trustee. So a lot more control in that setting as well. So when we think about probate, it exists because we need it to. We have to have a process where title transfers somebody that passes away. We have to have a venue where we can bring our grievances against a deceased estate. Maybe we have a bill they need to pay, or an issue, a liability related to their estate. So those are all important things. But when it's just your typical family business owner who just wants to easily transfer assets and to their loved ones without conflict, the least amount of time and cost, and control how those assets transfer, maybe even for generations, controlling the process of transfer of generational wealth for minors, for those with special needs. Just probate is just not the answer, and it never will be because there is no control really. You have to follow the court process and the probate code. Um, and you don't really get to be very creative. And in the trust contest, you can be very creative and make sure that the plan fits the needs of your family and loved ones.
Can you touch on real quick what happens if, let's say, a family sets up their trust, everything's perfect, but they leave the business owned by one or both out of the trust? Let's say it's a one owner business, it's one of the spouse, and it's just left out. What happens? Do they still go to probate for the business, or how does that work?
Yeah, the business, depending on the entity's governing documents, it's going to follow what the process is in those documents for purposes of transfer of either shareholder interest or membership, LLC membership interest. If it's a, partnership just on by way of business, but there is no governing documents, it makes things even more difficult to try and decipher, what was the interest of the person who passed away as opposed to their other partners, and how can we capture their interest. Um, I would say it does open the door for probate pretty widely. If there is no proof of intention of the business owner to have put their business in their trust and have the trust govern it, and have the trustee have the ability to step into their shoes and either, sell the stock back or transfer the interest if it's not a stock interest, or so whatever business interest to their loved ones through the trust. Um, Typically there is a sale type of event, a trigger event like a death of a member. Most of the governing documents have something about like a right of buyback from the other owners, which makes perfect sense, right? You don't want to be in business with your partner's cousin's ex, like random just person. You have no interest in running a business with them. You never planned on doing so. And so there is a I would say leaning in most governing documents to make sure that the control of the entity and the intention of the entity and remain stable according to the initial intent. So you don't want the future members or owners or shareholders to look nothing like what it started, and not be able to continue the business into further generations. So um, yeah, if there is no clear proof that there is an assignment of interest, either stock interest or membership interest, or any kind of assignment legally signed by the person who passed away, who was an owner and had an interest in that company or business, then the directors and the officers or the managers and the shareholders, everybody with an interest in that business can't really act. They can't, who are they going to act with? Who has authority on the decedent's estate to make a decision? Well, nobody does if the person who passed away is gone and the interest is not in the trust, so the trustee can't do it. The power of attorney is not effective anymore because the person passed away. It's only effective during their lifetime. So it's a big question mark and usually requires someone with authority to act on the person's estate. And that will almost always require an appointment by the probate court or some kind of probate court order to give someone authority over that person's interest in the business because it's governed by their estate. And so it becomes like separate entity, a separate part of the process. And if there's no clear assignment into the trust, then unfortunately we would see it go through probate.
And hopefully this is valuable for all of you to hear for your clients and even maybe even for yourselves as we walk through this. We have touched on trustee and there's the role of the trustee, but we are also, as advisors, going to be interacting with the trustee. So it is important that we understand these rules and how to be a resource. So our question to you for this one is, do you know what the first action of a trustee is? Noelle, I'm going to hand it off as they come through.
Okay, I love it. This is great. I would say think about what's going on in the world of the people who survive, right? And the assets, the nature of the assets that survive the person who's passed away, who has put all their assets into this entity called a trust and has given power to the successor trustee, which is a manager of the trust assets, to come in and essentially take over, okay? Appraise assets, manage them, do what's required by law as a fiduciary, and then distribute them. Basically, take the assets from point A to point Z. Um, but nobody really talks about the granular kind of day one, what happens when someone passes away. Um, Typically, the person who is trustee should have known that they're trustee, right? Sometimes they find out later because somebody hands them the trust document because they can't do anything over their loved one's estate. Oh, I tried to call, sell the house and they told me it's in the trust and I looked at the trust and I'm not the trustee. I thought I was. And so now they can't sell it, right? So they go to the trustee and they say, "Hey, you were listed in this document." Obviously, not ideal planning. We want to make sure the person that's listed as successor trustee on our documents is aware. They've told us that that's okay. They have a copy of it. So in the kind of ideal scenario, the trustee is aware and they know. The first thing would be to know what the governing document says about their role, just to make sure there's nothing time sensitive in there or a particular asset that was supposed to be safeguarded or handled in a certain way with particular care is not inadvertently missed because we just assumed, oh, the trust is going to give everything to the kids equally. Well, I don't know that. Did you read it? Do we know what was actually required? Maybe there's a specific gift. Maybe there's a specific instruction that is time sensitive. And so reading the governing document would be, I would say, number one, which is it's kind of, we don't want it to be binary, like you only can do one thing at a time or like linear, do step one, do step two. It's kind of this a whole array of things that you have to do and different hats you're wearing as an investigator of what the assets are, what's going on with the family, what's happening, with the death certificate. We have to order that pretty early on, make sure that comes in because the trustee won't really be able to do a lot without it. They can't submit it to any of the banks. Or rather, none of the banks will issue them any power over the assets without proof of death. So, getting the death certificate, making sure the family, has the support they need if there's any funeral or end of life expenses that need to be paid, kind of keeping track of those, logging what those are. In the ideal scenario where the trustee can get access to trust accounts pretty quickly, they can start reimbursing family who may have advanced certain costs for funeral or end of life arrangements. And so that's important to take care of those, as well as putting a stop on any credit cards or automatic payments that may not apply. Some things that are on automatic payments you want to keep, like insurance and maybe phone bills because you still want to have access to the decedent's records for some reason. But some other things may not be applicable and you just don't want to keep the loss of funds because as trustee, you're supposed to grow the trust assets, make sure there's no inadvertent loss of any assets. And so you want to safeguard real property, maybe change the locks, making sure that nobody will get access to the property. And so those are things that are, I would say, granular, boots on the ground, things that have to be done. You tell the credit card companies to stop charging interest and stop letting any payments come through. Those things are important, I would say. In the grand scheme of things, they can be done later, but I would say if done correctly, they should be checked off first because you don't always need a death certificate to do those kinds of things, and you can start safeguarding the assets pretty early on. And then from that point, you would typically, if you don't have knowledge, or if your client who's trustee doesn't have knowledge because they're a family member, they really don't do this professionally. They're not licensed trustees who've studied how to do this. They typically need some assistance by a trust attorney to read the document to them and hold their hand through that process and carry some of the legal burden of the notices that have to go out to certain government entities, certainly notices to the interested parties of the trust, which are rather the beneficiaries and heirs of the trust, whether they're listed as beneficiaries or not. There's a whole kind of a list of who the interested parties would be. Notices need to go out to them with a copy of the trust. And that could be very cumbersome depending on how the trust is drafted and the dynamics of the family. And it's not typically something a layperson wants to take on, even though they're competent enough to do it. It makes a lot more sense to hand off that certain task to the trust attorney who does it for their clients all the time and is going to do it correctly and efficiently. So I would say along that spectrum of all the duties that have to get done sort of simultaneously, finding a competent and trustworthy trust attorney is one of those first tasks, just so you're on the front end of any issues that may come up. And reconnecting with the decedent's advisors. It could be their financial advisor, their CPA. Those are the folks who know the most about the decedent. And if they left information about who they are, it would be important to connect with them and just say, hey, just to let you know, so and so passed. I'm the successor trustee. Like let's connect to see if there's anything that needs to be done. Because they might have insider information that didn't get put into the trust for some reason, or some intimate details about the family that could be really relevant to making sure things get done easily without conflict. And again, we're on the front end of any unexpected occurrences in the estate settlement process.
Awesome. And as you guys are thinking about all this, there is one more section of this kind of conversation that is important, and that is, well, what happens with the trust if grantor is alive? How do you give this control? So there is something called the power of attorney. If they are now not able to, they're still alive, but not able to act on their own. My question to you is, when is a client's power of attorney considered too old? There are some rules around this. Let's see what you guys know.
One of the most, I would say, confusing and misunderstood and misnomer words that get mixed up is power of attorney, trustee, and executor, that they are all different things. And a lot of people use them interchangeably. And I don't blame them because they don't do my job. And so they don't come across these issues as much as I do. But it is confusing. And it's important to know what the role is of each of those and how they can act on the estate and why and when, and to what degree and what kind of enduring authority they're given. And so I know it's a super lawyer answer, but it really depends. It really depends what kind of power of attorney we're talking about. Is the person who is the principal, they call the principal, like the person who's alive, who's granted that power, are they still alive, right? And do they still have capacity or not? And maybe how old are they? Like that's very relevant too, I think, because I will answer when it is too old, but I think it's helpful for you to also think about when is the power of attorney being used and who is reviewing it to tell you that it's too old. Okay, so let's think about a scenario where we're using a power of attorney. Typically, it's for assets that are not in the trust, because if it was in the trust, guess who has authority over it? The trustee. Okay, so even if the person who created the trust is incapacitated, they're still alive, but they can't act. We know who can act. It's the trustee, and that document is not going to get attacked. It's really reliable. We know that it's going to be followed. Nobody is going to say, hey, your trustee document or your trust document's too old. We just never heard that, or it's expired, or whatever the case may be. That's just not a thing. Um, Typically because of the fiduciary nature of the way that the trust is created and the trust laws that exist surrounding how to manage trust. But if the asset is not in the trust, okay, so we're talking about maybe a bank account or a brokerage account or a retirement account or a policy, an insurance policy, something that is financial, legal in nature, the person who is called the principal can't act for some reason. So they have a power of attorney who is essentially person who legally steps into their shoes as if they are the person and acts on their behalf during their lifetime. Okay. So some powers of attorney are very narrow. They say, I give you the power of attorney over my car, right? For the next 5 years. And it says it in the document. What are the powers over my car? For how long? In 5 years. And then after that, the document itself says it expires. Okay. So we can actually look at the document and say, okay, what's the scope of the action and what is the end date, so to speak? I would say those are very uncommon. People usually get a very general form, a statutory form, either online or an attorney drafted form that is really broad. This power of attorney has authority over all these things, which makes sense because you don't want there to be something they don't have authority over and then they have to go to court and get a conservatorship. So I think from a planning perspective, it makes sense, but the person who's signing it needs to understand I'm giving a very broad authority over all these things to people during my lifetime who can step in and act for me and potentially no expiration date on that because it's usually a durable power of attorney, means that it's ongoing, it's going to continue, and there's no expiration date unless it's written in the document. And it's usually effective upon signing, unless we make it upon incapacity of the person who grants it. So, with all that in mind, who is going to say no, this is too old, or no, I'm not going to use this, this is expired, even though it doesn't, the document itself doesn't say I'm expired now. It's typically the party who has to rely on it, which is going to be the banks or the IRS or an insurance company or any other fiduciary you're dealing with who's handling this person's affairs during their lifetime. Their spidey senses are going to go up when they see a power of attorney. They should not just accept it blindly because we actually don't know the process by which this power of attorney was signed. All we know is that it's signed and notarized and we can rely on it. Sure, you can, but there's typically a due diligence process. And so the bank will take the document and say, okay, I'll get back to you. We'll now submit this to our legal team. And one of the biggest things they look for is how long ago was this power of attorney given and signed? And if it's drum roll, a little bit over 10 years, they're going to be suspect of its efficacy, of its accuracy, of whether it's still timely and current to what the person intends. Because as you could see, there is such a broad um, huge, I would say, propensity for misuse and abuse of this document. You get somebody to sign it, it's effective immediately, you take it to wherever they need to, you want to use it, and then they accept it. And then you do ever nefarious, fraudulent things, not you, but the person who wants to do those things. And then that person doesn't get caught until maybe later, but the damage is done. And now the family is trying to claw back assets that were fraudulently taken from certain accounts or decisions that were made that should not have been made, etc. So we definitely don't want to just give the power to anybody, which is why the banks and other financial institutions are going to tread carefully when they see a power of attorney. Even when the document is attorney drafted, I've still had clients say they want me to go in person, they want me to call them and submit all this other documentation. And it's true because the banks just they don't want to take on that liability because if they say yes to a document that should have been suspect to some reasonable eye, something that is very old or or very new when the person is old and it's a new document, and you know that they're incapacitated to some degree, but they've just signed this power of attorney. That also may trigger some spidey senses. So the bank's always kind of trying to figure out what's going on because they don't want to take on the liability for having relied on a document that they didn't do any due diligence on confirming its um, trustworthiness. So, with that in mind, I say it depends, right? It depends on the power you're giving, it depends on the principal's capacity, how old they are. Whether they intended to give a durable authority, broad authority, effective immediately or not, very helpful if it's more as current as possible. It doesn't have to be every year, but I would say if you're updating other documents, might as well just update the power of attorney as well. The likelihood is the folks on there may not be the same level of trustworthiness that they had before, and maybe you're out of touch with them. The better to update it. It's not that difficult to update, and it'll save your loved ones some of the headaches that comes with trying to take some very time sensitive actions during your lifetime. Because remember, this document is not going to be submitted once you're no longer with us or once the client's no longer with us. Um, it'll be submitted during their lifetime for some things that need to be cleaned up or decisions that need to be made, legal or financial. And it's important that it can be relied upon and that there's no multiple versions of it floating around the person's home, that they properly revoke the prior ones. Usually signing a new one revokes any prior ones, but it doesn't mean that somebody can't find the prior version and try and use it. So also important to make sure those documents are safeguarded and that you do, like Amanda was saying, update your advisors. Hey, this is no longer the correct version. Here's the correct version. Please put this one on file, because you don't want your advisors using old documents and not knowing your current intentions or your client's current intentions. I would say one helpful way to think about a trust and why somebody needs it, because a lot of times your clients may say, well, I don't need a trust. I don't have a lot of assets, or I don't have kids, or whatever in their mind is a reason to not do further planning. And I would say it's akin to saying, like, why do I need my vitamins? You don't need them. You're not going to get in trouble if you don't take them, but it's a precautionary planning adult thing to do that is clever and prudent and helpful, and accessible. And you just start somewhere, right? Even if you're going to do something online or take an opportunity to work with a company who's giving it to you half off, I don't care. Just do something. Just like you take some vitamins versus the ones that cost, hundreds of dollars. Like, start somewhere. It's kind of that attitude of stewarding, taking care of your affairs, making sure that you're not leaving a huge gap in planning for your loved ones, and that you can have a big impact with as little as you do have or may have or your clients may have. You can make sure it stretches and that it goes to the goals and values and objectives that you hope for your loved ones. And I think, if anything, the control aspect is really, I would say, the most compelling reason, in addition to privacy, for why a trust is needed, regardless of the person's value of their estate. It's a great planning tool and a precautionary, right? For anything that will come in the future. It just gives us that certainty that what we have in writing will be followed, can reduce conflict along the way, and everybody wins.
Wow, what a session.
Yeah.
I'm gonna drop this. This is just for you to think about because obviously we want to respect time, and Noelle and Paul have so graciously given so much to us. But think about your clients, your connections, those that you're working with. If anything touched your heart, and think about how you can open the door to, obviously Paul had mentioned that free consultation just to explore where they are. But before we get off today, and thank you, Noelle. Thank you, Paul.
Thank you.
I want to say thanks so much. Thanks, Noelle. Thank you, everybody.